All rise. The Second Judicial District Court, the state of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in state of Nevada versus Roger Hillygus and Stewart Handte. The court has previously excused Mr. Hante's attendance from this hearing. This is a follow-up to yesterday's hearing where Mr. Hillygus expressed concerns about his health and his ability to proceed to trial starting on Monday. The court deemed his request to be an oral motion to postpone the trial, to continue the trial, to allow him to regain his health so we could go forward. The state strongly objected, indicating that it did not feel that either really a hearing or that substantively the case had been made to justify continuance, indicating the state believed it was a ploy or an act designed to obstruct the administration of justice and not a sincere request to allow Mr. Hillygus to regain health sufficient to move forward. Because the court wanted more information about Mr. Hillygus's health, and because the hearing yesterday was not set up or noticed for that, and to make sure that Mr. Handte and his counsel as well had time to prepare, the court indicated it would hold a hearing either Wednesday of this week when we were set to be in court anyway, or today if we could manage it. Taking into account there are many moving parts in preparing for a trial, and so the sooner parties knew if this case was going Monday or not, the better. And so we were able to arrange a representative of NAF Care to be available virtually, somebody with direct knowledge of the care being rendered to and condition of Mr. Hillygus, as well as I understand an administrator, senior administrator from NAF Care in the Reno area is present in the courtroom today. The reason we're having a remote witness is because the person most knowledgeable apparently on Mr. Hillygus's care is out of the state today, and so this was the best alternative to hear from that person. The court recognizes that with a virtual hearing in the courtroom, it's a little awkward because the camera that focuses on the bench, I'm now looking at, it's up on the wall, but the monitors where witnesses are shown to the members of the audience, the jury, counsel, the accused, or the court are up on the wall to my behind me on either side, and also I have a monitor here to my left, so that occasionally when a witness is testifying remotely, if I'm looking at a monitor, they'll just see the side of my head. I also would note that both Mr. Hillygus, Mr. Silverberg on behalf of Mr. Handte, and the prosecutor have microphones, and so when you're speaking, put the microphone directly in front of your face. Please make sure it's on and speak loudly so that anyone who's appearing remotely can be heard. All right, so without further ado, I would like to hear from the administrator who's here in court to see who he or she is, what their role is, and if they could please identify themselves and come forward. And I'm going to ask you a few questions under oath. If you would please come forward, raise your right hand, and take the oath of witness.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Thank you. Would you please have a seat at the witness station? I'll ask you some questions, and then I'll let counsel and Mr. Hillygus ask questions. And let me also say this. Before we proceed on issues with respect to Mr. Hillygus's medical care and condition, Mr. Hillygus, you have a right to have this hearing closed, in which case there would be no media presence, and also I could also direct people not directly related to this case to step outside, and I could seal this hearing and make sure that it's not available to people other than those connected with the case, because they may go over, and likely will, what would otherwise be protected or confidential medical care, condition, and status of yours. I mentioned that yesterday. Have you given thought on how you'd like the court to proceed under those circumstances?
We can proceed as you see fit. I don't need the cameras to be removed from the courtroom, but I would ask that the administrator here has had emails and grievances that you've ordered to be provided to me for today's hearing prior to the hearing.
Well, let's just talk about
She
whether,
hasn't, but I have not been provided those.
okay,
But she hasn't.
we'll get to that in a minute, but in terms of having cameras in court to record what's happening, or audio to record what's happening, are you comfortable having it remain in open court?
Yeah, but part of what will become apparent is through these grievances that I want to address through the witnesses and through the court. And so I need those in order to be provided to me prior to this hearing, but I have not had them yet. I've been told she has them, and I would like to have those before we proceed.
Okay, well, we'll get to that in just a minute. Mr. Stege, any objection to the court proceeding in open court with a hearing like this?
No.
Any objection, Mr. Silverberg, on behalf of Mr. Handte?
No, Your Honor.
All right, so we'll get to grievances or communications here in a minute. Would you please tell us your name?
Kendra Heft. My professional name is Kendra Heft.
Say it one more time.
My professional name is Kendra Heft.
How do you spell your last name?
Hoef as in Frank. T as in
Okay,
Tom.
I'm gonna need you to slide in and get the microphone right in front of you, and if I would ask you to please speak up.
Okay.
Thank you. What's your current job title?
I'm the Health Services Administrator at Washoe County Jail, Director of Knife Care.
Understood. And what are your job responsibilities, please?
Oversee medical and the medical care of our patient population.
And will that include Mr. Hillygus?
Yes.
All right. And when you were notified that the court wanted to inquire as to Mr. Hillygus's medical care, attention, status, and essentially get the person most knowledgeable about that, is that person you, or did you designate somebody that could be that person?
I designated Dr. Elliot Wade, who's here via Zoom today.
Okay, and is that a licensed medical professional who has been rendering care to Mr. Hillygus?
Yes.
And I'll hear from him in just a moment. To your knowledge, is he licensed to practice medicine in the state of Nevada?
Yes.
Okay, and have you worked with him before?
Yes.
Are you confident in his abilities?
Yes.
All right, now you heard Mr. Hillygus a moment ago mention something that he believes you might have in your possession or under your custody and control. What he mentioned yesterday in the court order, grievances, but the sheriff indicated it would liberally construe my order to get to the essence of it, to be communications with respect to his health care. Were you aware that that was something the court asked to be produced today?
I was unaware that you asked for me to provide it to him directly.
Okay, did you give it to somebody else in the sheriff's office?
The district attorney's office.
All right, does the DA have that with you, and if so, do you have a copy handy? Mr. Stege?
I believe I do it.
Can I say something? They're not actually medical grievances, though.
Are they grievances, are they health related?
Mm.
Go ahead, Mr.
It looks like it's more of what we've seen a lot in this case, which is people affiliated with sovereign citizens sending an email blast to the entire world, politicians, etc., making very broad and unsubstantiated.
No,
I would object that these are emails, they're grievances addressed to the Washoe County facility and detention facility, and they're clearly a medical grievance.
okay, of a medical nature?
Yes.
I don't know.
There is a process that grievances are sent to the medical staff that Mr. Hillygus is very fully aware of how to send those notices through the smart communication system so that our staff does receive them, and they are labeled grievances, medical grievances, and they are addressed to medical. There have not been any of those in the last few weeks from Mr. Hillygus sent to us.
Well, I'm confused now, because I understood, according to Mr. Hillygus yesterday, there were 2, perhaps 3 grievances, or the term he used, that I understood bared on his medical care or condition, and I wanted to make sure that if he wanted the court to consider those as part of the decision whether he's able to go forward with this trial, that they would be produced. So do they exist or do they not exist, and if so, where are they?
He's got them in his
Okay.
hand. I would like them to be produced because they are medical grievances, but that they were sent as emails, and the reason why is the tablet has a small box and it does not allow to fill in the complete essence of the grievance. So it was sent as an email, and that email was forwarded, and it's addressed to the sheriff's department, it's addressed to all the professionals that are handling my case, and it's clearly addressed as a medical grievance.
All right, so Mr. Stege let's make sure we're talking about the same thing. Does the witness produce these to the district attorney's office in compliance to her best of her ability with the court order?
I believe so. I don't recall a court order. I don't know why we're here. This isn't a medical grievance court that we're in.
Well, it has to do with information that Mr. Hillygus wanted to present to the court that may bear on his medical care or condition.
Well, his care is really irrelevant to this court.
Well, I'll decide what's relevant. It's relevant to the court's decision. What I would like you to do, though, is please approach the witness and ask her if these are the universe of what she recovered and forwarded to you.
Will you please review what we'll shortly mark as Exhibit 1?
Yes.
You want to thumb through it to make sure it's everything that you pulled together?
This is what was sent to me by one of Mr. Hillygus' companions that he deemed as his medical grievances, yes.
Okay, well, so these don't come from you, Mr. Hillygus, they come from somebody else on your behalf?
They come from me. I send them as an email because the grievance tablet does not allow.
Doesn't allow me
does
to
not to give-
describe it in detail.
So I had to send it to someone else and ask them to forward the emails to the Washoe County Sheriff's Department as a grievance.
Please retrieve those from the witness. Let's have these marked as Exhibit 1, but Mr. Hillygus doesn't have a copy of these for today's hearing. Let me have a look at them, please. Thank you. Doctor, we're going to get to your testimony here in short order. I appreciate your patience.
You can have my copy, Judge.
Okay? All right? The record should reflect Mr. Hillygus is being provided a copy from Mr. Stege. So the first email is from Dr. Wade to other people, right?
Yes, I think the court needs to flip a little bit more towards
Okay.
the back from the aforementioned Mr. Scarlato's.
These are not the grievances that I filed with the Washoe County Sheriff's Department.
None of them?
I did not see them. No, I did not. This is the first I've seen of any of this. I don't know what this is. This is something that was sent to Amos Stege. It was not sent to me, so I would object to any of this being presented as evidence because it has not been provided to me prior to this hearing. I'm not prepared to address any of this. This is not the grievance that I filed. I would ask that this hearing be vacated and that I be allowed to get the grievances that I filed through an email, and I will make sure that they are sent to the Sheriff's Department, and then I can move forward. But I object to all of this as being ambush evidence. I do not know what any of this is. I have not seen this prior.
You haven't seen any of these before?
No,
No, they weren't, none of these were
No.
sent on your direction?
no,
So the 2 or 3 things you mentioned yesterday, none of them are here?
that's correct.
And you've explained to the court that since the box is limiting the amount of information you can put in there, at your direction, you had other people send emails on
I
your,
sent the email, I typed up the email on the tablet and sent it out and asked them to send it to the Sheriff's Department as a grievance on my behalf. Because it's not effective. The box does not allow for enough information to be addressed.
okay. Well, as to the representative from the Washoe County Jail here, your role is, again, can you just describe, please, one more time, your role with respect to Mr. Hillygus in particular, his care?
I oversee the medical providers that provide him care specifically. We discuss his care on a weekly basis. In addition to that, I have visited Mr. Hillygus on several occasions to provide him medications, complete assessments, make sure that he was doing well in our facility.
Okay, do you have any reason to believe he has not been doing well?
No.
None whatsoever?
No.
Have you heard that he's indicated that he was left out in the sun for 2 hours inappropriately, and that caused him duress, discomfort, or adverse medical sequela, consequences?
Yes, I have heard that.
Okay, and what do you make of that?
In reviewing video footage and doctor's notes and visiting Mr. Hillygus myself, I believe that
I would object. I
Hold
have
on.
not seen any of this video footage. This is ambush evidence. Once again, this is inappropriate. I object to this hearing moving forward, as I have not been provided any of this information, and this is not the information that I was prepared today to address.
All right, your objection is noted. I'm going to go forward, though. Please continue your answer.
I do believe he is in good health that can continue with this process.
Well, why do you say that, though? You've heard some of the, has it been made known to you what some of the concerns are here?
Yes, it has.
All right, and again, what do you make of that?
I believe that he's been provided the adequate medical care that he needs, and that he is receiving the care he needs in order to move forward. That after the incident, or the supposed incident, of being left outside or being outside for an extended period of time, that he received medical care at the facility that was adequate.
Mr. Stege, any questions of this witness?
Are there any lingering effects from this being left outside incident?
Not that I have noted.
And you're a trained medical professional yourself,
Yes,
in addition to being the administrator over other medical professionals.
yes, sir.
You meet with the treatment team once a week regarding this defendant.
Yes, I do.
You do that with respect to all defendants.
All of our defendants that need or are requesting medical care from our team.
Among the inmates in the Washoe County Jail, is his level of care, isn't it true his level of care is quite low?
The need for care is quite low, yes.
And yet he is, in fact, you were here, the person who was here yesterday when we asked for this hearing, correct?
I was here yesterday, yes.
Okay. And so you were then as knowledgeable as you are today about his conditions.
I would say I'm a little bit more knowledgeable today, as I heard that this was happening and felt the need to make sure I knew his care through and through.
Do you see any barrier to him proceeding to trial or any other type of courtroom
I do
procedure?
not.
Have you, you've noticed a number of objections or obstructionist behavior by the defendant. Is that consistent with the behavior he exhibits?
Well, let me have him finish the question first.
The behavior he exhibits while in jail?
Oh, hold on. The objection is that's not relevant to what we're here to talk about today, or?
Yes.
It may be relevant. The objection's overruled. You can answer that.
Will you ask it one more time, please?
It's true, he's a very demanding patient or inmate.
Yes.
That's not what was asked.
Oh, he rephrased the question.
He doesn't make requests, yes.
And you've seen in court that he's, one might say, obstructive. Is he the same way in jail?
One might say yes.
And you said you watched the video of this being left outside.
Yes.
And what does it show?
It shows that timelines were a little exaggerated and that he was not out there for the extended time that he states he was.
And what was the medical effect of being left outside?
He felt that he was dehydrated or that he started to have a sunstroke. So we made sure and to monitor and make sure that he was doing quite well and that those effects were not completely founded and that they were tended to as he needed them to be.
Okay. Were the effects exaggerated by him?
Yes.
Were anything concerning about his vitals at the time or his medical condition?
Not that's extremely out of the ordinary for him, no.
So we have before the court in this exhibit a note from the doctor indicating that Mr. Hillygus' use of a wheelchair appears to be volitional. You aware of that?
Yes, I am.
What does that word mean?
Meaning, what does that word mean to you?
More so not medically necessary, more so that it is his request and requirement.
And so, are you aware of observations of whether in fact that is the case, that he is able to walk but chooses to use a wheelchair?
I have seen situations of such, yes.
Let me ask you this, can you describe your medical training and experience, please?
I'm an IC nurse by trade, and then a pre-op PACU OR nurse,
Where did you receive your education and training?
Carrington and Chamberlain.
Okay, and how long of a program was that? What degree or degrees were conferred?
BSN.
Okay, Mr. Stege, any other questions?
Although the emails that were attached that you reviewed from the compatriots of the defendant, is there any, in your view, of that truth to the allegations contained there?
With respect to medical care or condition?
Mistreatment or intentionally leaving him outside, revenge or something?
Objection.
Excuse me.
Objection. Requires speculation on the part of somebody that doesn't understand what was written.
Well, the question really is, did she believe there were any factual inaccuracies? So you can ask it that way, or you can respond that way.
I do believe that his statements have quite a bit of inaccuracies.
How so?
The time frame that he was left outside, the demand to go to the hospital following the incident,
Did he go to the
I
hospital?
would object. It's relevant, it's not.
I'll let you have an ongoing objection to this line of questioning, Mr. Hillygus. Was he taken to the
There is
hospital?
no video.
No,
And why not?
there was no foundation for him to leave the facility.
Okay, Mr. Stege, any further questions?
Are there any ongoing chronic conditions that would interfere with the defendant's ability to be in court?
I do not believe so.
Separately, the defendant is claiming their separate grievances. Are you aware of any other separate grievances by him about his medical care?
No. The
And
grievances I received or the emails I received from his colleagues, I believed to be the grievances that he was referring to.
And has there ever been an occasion with Mr. Hillygus and his transport to and from court that caused a medical concern for you or your staff?
No.
Thank you, Judge.
Mr. Silverberg, any questions? If you're going to question seated like Mr. Stege, if you can please slide the microphone a little bit closer to you.
Thank you, Your Honor.
Thank you.
The emails that you provided, were there other emails that you chose not to provide?
No.
These are all the emails that you have in your possession?
That I have in my possession. Those are the only emails that I have received from any of his colleagues.
Okay, so there may be other emails that you didn't receive?
I'm unaware, so I cannot answer that question.
So those are the ones that you have, correct?
The emails I have forwarded, yes, those are the only emails I have.
And you printed out copies of those?
I did.
And you gave those to the state?
I emailed them to state.
Any reason they were not emailed to anybody else?
I don't have anybody else's email.
Did you talk to anybody else between yesterday's hearing and this hearing about your testimony today?
No.
Thank you.
Mr. Hillygus, you may ask some questions related to your care, your treatment, the event from the other day when you were left outside, the information that the witness has discussed here.
I heard that you're qualified as a nurse. Are you qualified to prescribe controlled substances?
No.
Have controlled substances been provided to me?
No.
Am I currently taking medications that have been prescribed by a physician?
Yes.
Upon being booked Was I evaluated by somebody from NAMCARE?
Yes,
Did they determine that I was to be in an ADA cell?
upon being booked into the facility, no.
Is it not true that a nurse named Janet that works for NAMCARE wrote on a card, on my booking card, that I'm to be in an ADA cell? That I use this card everywhere I move within the facility, and that I've been in an ADA cell since I've been there for 8 months?
I'm unaware. I cannot answer that question.
Do I use the shower in the infirmary as an ADA shower?
Yes,
Is that the only ADA shower in the facility?
I believe so. I'm not 100% certain.
Would I be allowed to use the ADA shower if I was not determined to be ADA?
That is a custody question.
Is the ADA shower allowed for people that are not determined to be ADA? Can anybody use that shower?
I'm going to default to that as a custody question.
Can an inmate get a wheelchair without being prescribed? Can he just go grab one and use it? Or does it have to be ordered and provided?
It needs to be provided.
Are you qualified to do evaluations, and have you evaluated me?
Yes,
Can you explain when that was and what exactly evaluation was performed?
just a physical assessment, just to see how you were doing. A set of vitals were taken, conversation was had to ask if you had any medical needs at that time. Mental health needs or dental needs. In an ongoing assessment that we provide for you to make sure that we are providing you all the needs that you are requesting or you feel that you need medically.
On the day that I was left in the sun, you said you watched the video, is that correct?
Yes,
Has that video been provided to me?
I'm unaware that is a custody question.
Has that video been provided to the prosecution?
I'm unaware.
Was I evaluated by medical professionals on that day?
Yes,
Can you name who they were?
I can.
Can you name them?
Billy Botany, Rex Weeks.
Are those two people or one?
Oh, and Rex Weeks, as well as a few of our nurses that were there that day.
What was the first name that you mentioned?
Billy Botany,
And what is her title and position?
nurse practitioner.
Is she licensed by the medical board
Yes,
or by the nursing board?
she is a nurse practitioner. She's licensed by the nursing board.
And is the other person that you mentioned, Rex Weeks, is he a licensed physician?
He is a physician's assistant.
Is he licensed by the medical board, physician's board, or by the nursing board?
He's licensed by the medical board.
Is he available today?
He is unavailable today.
Is he the one that prescribed me medication?
He has prescribed you medication.
What medications has he prescribed?
Without looking at your chart, I do not have that information at my fingertips.
I was unprepared for this line of questioning with this witness. This is an ambush. Once again, I object to this hearing and to what's occurring here today is completely inappropriate, it's unprofessional, and it's a deprivation of my rights.
Well, I would note that there was an oral motion on the Monday before the Monday of trial, not a written motion for the opportunity for people to respond in writing, but an oral motion to postpone this trial. So the court is moving as quickly and as it reasonably can to bottom this out to the best of its ability.
But if I can't defend myself, if I'm ambushed with emails that aren't proper, if I'm ambushed with witnesses, if I'm ambushed with not having been seen the evidence that they're talking about. This is completely unfair, and it's a lack of due process, and it puts me in a position of vulnerability.
Okay,
I
well,
object.
what I've heard is the one piece of evidence is the video that apparently the witness has seen, not the state, as far as I know. The court hasn't seen that, so nobody's seen that. In terms of these emails, I just thumbed through the very first page. I haven't reviewed them. I may not even rely on
Those
them.
aren't the right ones.
I heard you when you said those were the two
I
or
haven't
three.
even seen those until today.
Understood. All
I
right.
was to get those prior to the hearing, and I did not.
Okay, I understand. Based on the line of questioning just now, Mr. Stege, anything else for Ms. Hoft?
Heft.
Okay, thank you. Sorry if I mispronounced it.
Thank you. Yes, Ms. Heck, yesterday, Mr. Hillygus repeatedly referred to having an appointment with a medical provider at the hospital or.
I'm sorry.
At a,
Repeatedly
Would
referred to
you sit up
as.
and talk to the microphone, please? Thank you.
yesterday, Mr. Hillygus repeatedly referred to having an appointment off-site somewhere, either the hospital or somewhere else. Are you aware of what that is?
Yes,
What is it?
it's an eval appointment for the need for possible physical therapy.
Thank you.
Mr. Silverberg, any other further questions?
Thank you. Just briefly, what's he need physical therapy for?
Mr. Hillygus states that he has C7 issues going on in his neck, that he also suffers from a previous traumatic brain injury. And we want to make sure we're providing him the care that he needs in order for him to not have to be forced to utilize the wheelchair that he requests.
You think the wheelchair assists him?
In what nature?
Understand? Does it provide him assistance?
It provides assistance.
Do you know how his legs feel?
No.
No.
Mr. Hillygus, anything else based on those questions and those responses?
Not of this witness. I would object to the other witness as not evaluating me but one time, and that was for a fall injury that I sustained in the facility. I do recognize Dr. Wade. I did meet with him. He did order x-rays of me, but he did not recently evaluate me. It's my understanding he's out of Las Vegas, and he has not been at the facility. I have seen him but once.
Well, let's hear what he has to say, and then you can argue to the court why I should give it little or no weight as to what we're here to do. Nurse Happiness, thank you for your testimony. You may step down.
Thank you.
Thank you. All right, at this time, Dr. Wade, can you hear me okay?
Yes, Your Honor.
All right, thank you. I appreciate your patience. We're going to ask you some questions. Mr. Hillygus is allowing you to respond fully to questions put to you, even in a context of an open court hearing like this. So be aware of that. But we are going to place you under oath so we know that your answers are truthful. If you could please raise your right hand and take the oath of witness. Ms. Stege.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Dr. Wade, you heard me mention that if I don't look this way, you don't see my face. So I'm going to look to the side so I can see you. Can you tell us a little bit, please, about your educational background and professional training?
So my name is Elliot Wade. I am a licensed physician in the state of Nevada, amongst other states. I went to medical school at Emory University in Atlanta, Georgia. Graduating in 2005, I completed an internal medicine residency. We finished that in 2008. I am board certified. My current title is Regional Medical Director for the Western States for NAP. Here I oversee 22 jails in 8 states, including 4 in the state of Nevada. I help, amongst things, monitor lots of patients, providers, nurses, health services administrators, help set a lot of policy in regards to lots of different things, including medical assisted treatment. I'm sorry I'm not able to be there today. I'm currently in San Diego to attend a few sessions of drug court down here and get some things done, but I think Kendra reached out sometime late last night about needing some help. This is a case that I'm aware of because, as noted, I have seen Mr. Hillygus on at least one occasion and have received a few emails from different various sources over the past few months, which have necessitated my review of his case and his care, as well as advice for the staff on site over the past several months.
Okay, thank you. And so you're aware of why we're having this hearing, are you not?
In short, from my standpoint, our health services administrator, Kendra, reached out and said that she needed help and that there was a request from the court to have somebody knowledgeable in his care to be available without getting too off topic. It was determined that it would best be for me to handle that.
Okay. The court is trying to get information from which you can make an informed decision on whether Mr. Hillygus is fit to proceed to trial beginning next Monday, or alternatively, if he has something going on which can be treated or is treatable, such that he could be ready to go in the near future. He indicated yesterday that he doesn't think he's in a position for various medical reasons to proceed with trial. The prosecution strongly objected. His co-defendant was in agreement with the request for a postponement. The court needs to make an educated decision here. And so I invite you to please summarize Mr. Hillygus's medical status, and then if you have any opinions on how that might bear on his fitness for trial, to be transported daily, to sit through 6 to 8 hours with comfort breaks for bathroom and lunch, to listen to, understand what's occurring, and to be able to pursue his defense. Those ultimately will be some of the questions based on your actual engagement with him or your review of his case file or speaking to others. So I know that's a big open-ended area, but can you please talk to those? And it looks like you've started to summarize that in the form of an email, but you can refer to that if you have it handy, or go by memory if you don't. Go right ahead, sir.
Sure, thank you, Your Honor. So I was yesterday, or even, I guess even this morning, I wasn't sure if virtual court was, or this Zoom platform was available to us. And so that's why I wrote that email, because I wasn't sure at the time, hey, is this going to be granted? So that was the reason I said that. In terms of his overall care, he's a 56-year-old gentleman with a history of high blood pressure, a noted traumatic brain injury, what we call TBI, in the past. He'd previously been on some medication, specifically lisinopril, to control his blood pressure. However, he has chosen over several months not to take that medication, which is his right. When I saw him in March, Mr. Hillygus is correct that it was after a fall. I believe it was maybe 2 or 3 weeks prior to that. When I saw him, he was in a wheelchair, and most of his that interaction was about getting a supplement called triple magnesium, which we were able to procure for him. At that visit, he had noted some numbness in his toes, his feet, and his low back pain. And he noted, quote, coldness in his upper extremities with some color change. Given that complaint, I determined that it wasn't appropriate to try to get him up and try to walk him around. And really the discussion with both him as well as the staff was to get x-rays of his, Kendra referred to as C7, but that C stands for cervical. So to get x-rays of his cervical, thoracic, and lumbar spine. Those x-rays ended up showing no fracture, but did show that he was having some muscle spasm. Mr. Hillygus had noted a condition called a neurogenic bladder, where the bladder doesn't truly respond to sort of normal stimuli. It was his belief that the triple magnesium would help that condition, as well as his condition in regards to his bowel control. After I saw him, it appears that in May of this year, he asked for an ADA or Americans with Disability Act shower chair. In July, there was a note sent that ended up coming to me that he felt that being incarcerated was detrimental, deteriorating, and declining effect on his physical and mental capabilities. The provider at that time allowed him to have a snack and some Gatorade with the thought that maybe that would help. Within a week, I think about 8 days, he noticed some chest pain radiating to his right arm, and on July 25th, he was sent to the hospital, given that concern. He was returned from the hospital that same day, determined not to need admission to the hospital or have any other condition or abnormality that was preventing incarceration or needing referral to a specialist. In review of his labs from that ER visit, it noted that his kidney function was consistent with chronic kidney disease stage 2, which shows a mildly reduced function, which is actually fairly typical for somebody with high blood pressure. And generally speaking, the recommendation would be to treat the blood pressure to not have any further compromised kidney function. Interestingly enough, the medication that he was on previously, like lisinopril, would actually be really good to help prevent any further damage to the kidney. Again, this damage is long-term, it's not an acute thing. Since that time, he noted to the staff that he felt that he would benefit from electrolytes to help treat his neurogenic bladder. As far as I'm aware, I've never seen a study to suggest that someone needs electrolytes to help their neurogenic bladder. With that being said, the labs from the hospital on that ER visit on July 25th showed that his electrolytes were normal. Certainly being hydrated with water certainly helped. And as far as the wheelchair, again, as Mr. Hillygus said, I only saw him personally in March. There has not been, as far as I'm concerned, any demonstrable evidence as to why the wheelchair is needed, but I've also told the staff it's not worth arguing with him about it, just to allow him to have it, certainly to get to court. We know that he has an injury from prior to incarceration, and so just to allow for the wheelchair, I think would be fine. But as far as I can tell, there's no acute issue that would preclude him from attending court. I think certainly, trying to make sure that, from your standpoint, that he's comfortable while he's in court, able to get to the bathroom, that sort of thing, I think would be appropriate.
All right, what about anything that you're aware of that would, in your mind, impair his ability, other than you've already talked about, to proceed to this trial? It's currently set for 9 court days, beginning a week from yesterday, and then proceeding the following week if needed, from the Tuesday through the Friday, because we have the Labor Day holiday. Are you able to identify anything substantively that the court should consider with respect to this request to postpone the trial?
I'm not aware of any mental health conditions that would preclude him, or any acute medical concern that would preclude him from attending court.
All right, thank you. Mr. Stege, do you have any questions of Dr. Wade?
No, thank you.
Mr. Silverberg, do you have any questions of Dr. Wade?
Just briefly, have you looked at any of Mr. Hillygus' medical records over the last 2 to 3 weeks?
Yes, I have.
And what did you learn there?
I don't think anything different than what I just reported.
What were those records?
His chart is available in our electronic medical record system.
Is it just internal?
In the last 2 to 3 weeks, yes. He hasn't been he hasn't been outside the facility to any other medical provider.
Thank you. Nothing further.
Mr. Hillygus, any questions of Dr. Wade?
I do have questions, but I'd like to object that I've never been prescribed lisinopril for high blood pressure. That was prescribed, or that was ordered by NAFCare to be given to me, and I refused to take lisinopril because I've never been prescribed lisinopril for high blood pressure. I just wanted to clarify that.
Okay.
Okay, Dr. Wade, at whose request are you appearing today?
The courts,
Okay, so you had ex parte communication with the court prior to this hearing?
He didn't say that.
He said the courts.
The court issued an order that was given to all counsel, to yourself, and to a copy to the sheriff.
I know you're employed by NAFCARE, but I did not hear how long you've been employed with NAFCARE, I don't believe.
5 years,
And before that, where were you employed?
a number of different places, including myself. I was a hospitalist for 10 years, working in a lot of hospitals in Nevada and throughout the country. So I'm licensed in a lot of states.
Can I address you as Dr. Wade, or would you like me to say something else?
No, that's fine.
Thank you. Have you sworn a Hippocratic oath to do no harm?
I would challenge the word swore and what that means.
If you ask him if he's taken the Hippocratic oath, maybe that's.
Have you taken a Hippocratic oath to do no harm?
At the time of graduation from medical school, without getting too involved, the Hippocratic oath is a part of that, but there are some parts of the Hippocratic oath which are questionable.
Is it your
And
practice?
by the way, I'll just comment on that. The court interestingly read an article about how different states and different universities are moving to a more holistic oath or allegiance to newly admitted physicians. So doctor, it's not lost on the court that there's been some discussion on what type of oath or what type of allegiance to be identified. But go ahead, Mr. Hillygus, although that's not directly relevant to the court's inquiry, but I'll let you ask a few more questions.
Is it your practice to help your patients?
Generally speaking, yes.
Is Mr. Hillygus currently your patient?
I believe so.
You admitted to evaluating him one time in March and not seeing him since, so please explain
So
how.
are you talking about yourself in the third person, or you're talking about yourself? Right, go ahead.
You've admitted to seeing Mr. Hillygus once in March. Have you seen him since then?
Not including today.
Well, you've seen me here, but have you treated me since March?
I have been asked about your care from providers who are on site, so I believe that would be yes, even though I would admit that that is not direct patient care.
So you've not had direct patient care with Mr. Hillygus, is that correct?
Not since that visit in March.
Have you discussed and reviewed with Mr. Hillygus his extensive medical history, and what are your findings?
Well, that's too broad of a question. I just had him go over. He's already testified generally to your current status and some of his findings. Can you be more specific? What's the point you're trying to establish to the court here, Mr. Hillygus? We can focus your questions.
That other than the one time that we've discussed and reviewed my medical history, have you done that since then?
Again, I've met with you in March that one time. Since that visit, you've been seen by providers on site who often have asked me my opinion or what they think or what I think they should do as far as next steps.
Can you explain to the court who are the licensed providers with the medical board at the Washoe County Detention Facility currently employed by NAFCARE?
Yeah, I mean, to the extent you know that, that's pretty broad. He said he oversees several different facilities, if I understood him correctly. So I'm not expecting him to roll off his tongue a list of people.
Well, he should know who the medical providers are at Washoe County. This is about me and this is about today's hearing.
The court would disagree on that point, Mr. Hillygus. But Dr. Wade, do you know any of the specific licensed medical practitioners that office out of the Washoe County Jail or have been involved in Mr. Hilligus's care?
Sure, but our medical director at Washoe is Dr. Joseph Benson. Our provider is Rex Weeks. He's a physician assistant. He actually has his physician assistant license under me as I'm his supervising physician, which is why Rex reaches out to me directly about when he has questions. Formerly, we had Billy Botany, without getting too off topic, her last day was yesterday. And then I'm not sure if there's a reference to the mental health providers that are there, but there's a Dr. David Fennell. He is a psychiatrist. We have Dr. Probably butchering her last name, Kendra can correct me if I'm wrong in the record, Dr. Yassar, Y-A-S-A-R. She is another psychiatrist. And then I believe we have a few other mental health professionals, but I'm not sure, and nurses, but I'm not sure he's referring to all of those people.
Thank you. Has Dr. Benson evaluated myself?
I'm not entirely sure as I sit here. He may have seen me one time, but I'm honestly not sure without looking at the record.
As the medical director, is that something normally that he does? Is he treats inmates, or does he have other responsibilities?
Personally, everybody that's an incarcerated individual, I like to call a patient because I'm not custody. Depending on the day of the week, it can depend if Dr. Benson has the bandwidth to see patients individually. I think in this particular case, given the complexity of it, as well as, again, since I'm Rex Weeks' direct supervising physician, I think it's been fine to defer to me on this. Just go ahead.
Thank you. Has Mr. Hillygus been treated by the mental health professionals in the facility?
I don't believe that I've seen any notes from the mental health providers, and I cannot recall if you've been seen by the mental health professionals.
Mr. Hillygus, I'll allow a couple more questions, and I'm going to wrap this hearing up.
I've got quite a few more questions. This hearing was regarding me, and I have quite a few questions that I'd like to ask of Dr. Wade. I know the court has weighed in and taken some of the time away from me, so I would object to ending the hearing without me being allowed to defend myself and to
Well, I'm not ending
question
the
the
hearing,
provider.
but I want to make sure these questions are relevant to the court's inquiry here, right?
Physicians that are supposedly treating me, that aren't treating me, that aren't physicians, that aren't prescribing narcotics, that, I mean, it's admitted that this doctor saw me one time in March, and he hasn't seen me since.
Well, you can make argument as to how the court should interpret his testimony, but I want to find out what he has to say, and then we're going to let him go on to do other things, and I'll hear from you and counsel on what the court should do.
Are you certified or authorized to prescribe controlled substances?
In general, or specifically in the state or in the jail?
In the state and the jail generally.
Yes, I have 3 DEA licenses in the state of Nevada.
Have you prescribed, thank you, have you prescribed needed medications for injuries Mr. Hillygus sustained while detained in Washoe County Detention Facility?
I don't remember when I saw you in March if I prescribed you medication or if you were already on those medications and therefore there wasn't a need for a duplication of those prescriptions.
Have you approved and scheduled a hospital treatment for Mr. Hillygus?
In the past, or you mean upcoming?
Upcoming. Have you approved or scheduled an upcoming hospital treatment for Mr. Hillygus?
No.
Do you know who did?
Well, let's start.
It was admitted by Kendra earlier that there's been a scheduled appointment with the hospital for an evaluation.
For
Are you
physical
aware of
therapy? Is that what you're talking about, Mr. Hillygus, for possible physical therapy?
that? And other issues.
Okay.
As far as I'm aware, there is a physical therapy appointment that is scheduled. I don't know if it's at the hospital, so I would not say on the record that you have something scheduled at the hospital. I just want to be clear about that.
Did you recently treat Mr. Hillygus for heat stroke or heat exhaustion?
No, I did not.
Is heat stroke or heat exhaustion a serious medical emergency?
Yes.
Can and do people die from heat stroke and heat exhaustion?
Yes.
Is medical hospital transport and IV therapy standard operating procedures for medical emergencies?
No.
Were either of these treatments offered or considered for Mr. Hillygus' medical emergency?
Well, hold on.
Do you
No,
know?
hold on. That assumes a fact, right? So what you went through was deemed a medical emergency by somebody, but can you rephrase that question, because that's,
Do you know?
hold on, Mr. Hillygus, let me finish talking. That has some assumptions baked into it, so I'm gonna make sure this is a fair question to the physician. Go ahead.
Do you know if either of these treatments were offered or considered for Mr. Hillygus during his medical emergency?
So again, if to the extent you can answer that, Dr. Wade, you've already heard the court's concerned with the use of the term medical emergency. I'm not questioning that Mr. Hillygus believes he was suffering a medical incident. He's made it clear that he did. But to the extent you can answer that question, go ahead, sir.
I would say that, to your point, Your Honor, that the incident was determined not to be a medical emergency and therefore did not require IV fluids nor transportation to the hospital.
What was he transported to the infirmary?
That I'm not sure. I would need to open the medical record.
Would there be video of that transport?
Considering there's video throughout the facility, I think in every location other than bathrooms, I would think that there is, but that would be a question better directed to custody as to whether or not that there's video about that.
Were his vital signs taken in the infirmary, and were they normal or abnormal?
I would need to review the medical record, but I would surmise that they were determined to be acceptable.
Was Mr. Hillygus dehydrated? Was he treated for dehydration?
I suppose the question would be whether on what day is that question referring to, because I believe there's been more than one complaint about dehydration on different days.
On the day that he was transported to the infirmary for the heat exhaustion?
I don't believe that anybody determined that there was indeed heat exhaustion, one, and then two, I would need to look at the actual date in question.
Through the video, can it be determined that Mr. Hillygus was exhibiting involuntary shaking and convulsions?
So that's, again, got a question, got some assumptions baked into it. We're asking to assume that there's video of your status, and if he had seen it, could it possibly have shown you to have those symptoms? That's speculation right now.
Are there video cameras in the infirmary?
I believe there are, yes.
So would there be video of Mr. Hillygus involuntarily shaking and convulsing while being treated for heat exhaustion?
So again, I don't know, one, that it was heat exhaustion, and two, if I were to see video with somebody shaking, there's lots of reasons why somebody could be shaking, some which are medical and some which are not, and I don't believe that by a video by itself you'd be able to determine that.
Was Mr. Hillygus prescribed Keppra?
You mean that recently, as a result of coming in?
On the day of the incident we're discussing, heat
Okay.
exhaustion.
Do you know the answer to that, Dr. Ray?
Keppra?
I believe Rex was concerned about the possibility of a seizure, but I don't remember if he prescribed Keppra. The generic name for that is levetiracetam. As I sit here, I don't know that, so again, I would need to review the record as to whether or not that was written to be able to answer that. it honestly wouldn't make any medical sense to me as to write that medication.
What is Keppra specifically prescribed for?
Typically, it's for anti-seizure.
Was Mr. Hillygus prescribed muscle relaxers to support the stiffness from a seizure?
That would be inappropriate prescribing, but muscle relaxants can be used for patients.
Was Mr. Hillygus exhibiting a stiff neck and stiff jaw, a classic symptom of a side effect from a seizure?
I would counter against that as a classic finding of a seizure. But yes, a muscle relaxant has been prescribed for you.
Can a seizure be triggered by dehydration and low blood sugar?
In theory, yes.
Has Mr. Hillygus been prescribed electrolytes for dehydration?
Electrolytes wouldn't be for dehydration.
Has Mr. Hillygus been prescribed hydration supplements for additional hydration needs?
I believe that Rex did write for Gatorade on one occasion, which I questioned, given the ER visit, which showed normal electrolytes.
Does Mr. Hillygus prefer a natural approach to health care, do you know?
I'm fairly certain that would be a yes. I believe he met with a physician in Dallas, Texas, and what that was kind of where the genesis of the request for a triple magnesium supplement came, that he felt that triple magnesium was beneficial to treat blood pressure, neurogenic bladder, and sorry, I'm blanking out, but a concern issue with his bowels.
Does it appear Thank you. Does it appear Mr. Hillygus is attempting to receive his prescribed controlled substances for nefarious purposes?
From memory, I don't remember that there was a controlled substance that you were on prior to incarceration. I believe that the pharmacy review, it's a system we call SureScripts. I believe that was negative. And again, I think the conversation that I had with you in March was that you prefer natural supplements, so I would think that a controlled substance would not be natural, therefore wouldn't be a part of it.
Is Keppra and Robaxin, are those controlled substances?
Keppra is not a controlled substance. Robaxin, it might be a controlled 5 substance, but that's one of those things I would Google real quick. Robaxin might be, like on the very lower level, but not in the same category. So sorry for background, there are different levels of controlled substances, 1 through 5, 1 being no medical therapeutic benefits, so things like fentanyl. Sorry, fentanyl is actually a Schedule 2. Something like carfentanil or xylazine, the stuff you see on the news, that's a Schedule 1, and then low-level things like tramadol, cough syrup with codeine might be level 5, and so I believe Robaxin might be in that Schedule 5 category.
Does Mr. Hillygus follow the rules for taking his prescribed medications?
Outside of the lisinopril that was written for and refused, as far as I'm aware, the prescriptions for the magnesium and the multivitamin and the muscle relaxant, you have been consistent with taking those. So I would say, again, outside of the lisinopril, I would say that the answer is yes.
Is Mr. Hillygus currently housed in the infirmary?
Ooh, I would defer to Kendra on that. I see the housing in the chart, but I don't remember what all the codes refer to.
Is the infirmary an ideal housing option for Mr. Hillygus? Why or why not?
Okay, you don't have to answer that. That doesn't inform the court's decision here.
Well, it does, because I am in the infirmary, and I'm in solitary confinement, I'm being isolated in the infirmary. And the infirmary is not a proper place for somebody that's trying to defend themselves, because you have inmates that are being forced medicated, you've got inmates that are smearing feces on the doors and the windows of their cells, you got inmates kicking and screaming and yelling all day long. It's sleep deprivation, and it's not an ideal place. I don't have a table or a chair to be able to work on my discovery and to be able to work on this case. And being housed in the infirmary is depriving me of the ability and my due process to defend myself in this case.
Right. Let me ask you, I'm going to let you ask 3 more questions of Dr. Wade that you think will inform the court, and then we're going to excuse him, and I'll hear argument like what you just made, if you believe that bears on your ability to proceed to trial. Go ahead, Mr. Hillygus.
Mr. Hillygus, did you want me to answer that last question about the infirmary?
Sure.
I think that is one of the harder things about taking care of incarcerated individuals, trying to balance their medical needs and the attention that we on the medical side give with the downsides, as you noted, that occur in the infirmary. So that infirmary or medical housing area certainly is, from our perspective on the medical side, that puts you as close as possible to the medical staff, so that effectively, I believe the furthest room from the position where the charge nurse sits on that unit, I believe the furthest unit is, the furthest cell might be like 50 feet. That might be a little bit too far. And so the benefit again is being close to medical, so that if you need something, that we're able to be, respond as quickly as possible compared to any other spot in the jail. The downside, as you noted, is that there are a lot of patients with mental health disorders. That's I guess a whole other thing in terms of just what ends up in the jail with having a lot of people who have mental illness. And it's our patients that have the most serious mental illness are in that unit, so people who are really in distress. And so, like I said, it's the hard part of trying to find the balance of your medical needs while being in a unit that's tough for everyone. I think in general, we've certainly had patients where they said, you know what, Doc, I hear you, I know that you're concerned about me, but please get me out of this unit. And sometimes it's not shared that nicely, said in more terse terms. But certainly if you don't feel that you should be on that unit, you think that you would benefit from being in another unit, then that might be worth discussing with custody and maybe having a meeting with custody and Kendra to discuss, hey, yeah, I know you guys are worried about me, but for my own mental health, for my own sanity, for my own peace, I think I'd be better served by being on a different unit. And I think that's something that could be discussed.
Thank you. Do prescribed and controlled substances that Mr. Hillygus has been prescribed, do they come with side effects?
Well, you already heard him say he's not aware of any controlled substances other
He
than...
actually said that he is aware that I'm taking Robaxin, and that's a level 5 controlled substance. So
Hold on,
substances have
Mr. Hillygus, hold on.
side effects?
Okay. So Dr. Wade, did you hear the question?
Yes, I did, Your Honor.
All right, what's the answer, please?
I think, in general, unfortunately, every medication on the face of the earth has side effects. Certainly, the magnesium is a side effect, even though it's natural. Having personally taken magnesium, if you take it on an empty stomach, for some people, myself included, it can cause an upset stomach. Robaxin, I believe that usually people are going to say they get sleepy with that medication, which is generally why it's written for at night.
Thank you. Do controlled substances come with warnings?
So, Mr. Mr.
It's also from a pharmacy.
I know,
They
Mr.
come
Hillygus,
with
you're
side
telling-
effects and warnings.
The court can take judicial notice of the fact that they come with warnings.
Well, this isn't, okay, well, so they
I'll
come with
accept
warnings.
that.
Is a standard warning not to operate heavy equipment or drive a car or to enter into legal contracts or attempt to defend yourself in a court while impaired.
Did you hear? Is that the standard, you're asking if that's a standard warning?
I'm asking if there are standard warnings that come with narcotics and controlled substance not to operate heavy equipment or to drive a car or to enter into legal contracts or attempt to defend yourself in a court while impaired.
You're asking if that's the federal,
I'm
notification?
asking him if there are warnings to this effect with medications that are prescribed by the pharmacy.
Again, the court can take judicial notice that with certain controlled substances, there are warnings and limitations on what the person taking the medication should or should not do when using that medicine.
I'm asking the doctor the question.
I know, but you're
You're
trying
not
to-
a physician.
You're trying
You're
to,
not a pharmacologist.
I invite the court to use its influence to maintain order with the defendant.
I understand, we're
I've
arm
got just a
wrestling.
few more
We're arm
questions. I
wrestling
know
here.
you said that.
So here's what's gonna happen. Mr. Hillygus, this will be your last question of Dr. Wade, then we're gonna excuse him. The court understands what he's testified to from all the questions from the court, counsel, and yourself, and then I'll hear argument. Go ahead, Mr. Hillygus.
In your professional opinion, can you state that Mr. Hillygus would benefit from a continuance in this case until after he can receive therapy, be housed in other than the infirmary, and be reevaluated for the substances that he is currently taking, which have side effects?
Are you able to answer that question, sir?
Your Honor, I had a question because I was unsure if I was supposed to answer the previous question or not.
Let's focus on this one.
Okay, Mr. Hillygus, could you ask that again, please? I'm sorry, because I felt there were three parts to it.
Yes, there are. In your professional opinion, would myself benefit from a continuance in this case until after I can receive the approved and scheduled therapy, be housed in other than the infirmary, where it's been admitted that that's not an ideal location, and be reevaluated for the substances that I'm currently prescribed and taking which have side effects?
I object to the compound nature of the question and the speculative nature of it.
No, it's a
Well,
three-part question.
hold on. I'm gonna let the doctor answer to the best of his ability. Dr. Wade, if you can answer all or parts of that, please do so.
So, Your Honor, since I'm not a legal person, I'm not sure what continuance means.
Means a postponement. It means a
Yeah, I was
postponement.
gonna say, okay. I was gonna say, my layperson, interpretation was to push it off.
Yeah.
I personally don't see why that would be the case, but it's also not my area of expertise. I think, again, moving a unit could be discussed, I think possibly even today. I'm not sure what reevaluation would do in terms of changing the thought today about being able to proceed with the court proceedings. Certainly, I do this not coming to court a ton, but having had plenty of patients in 5 years in custody, even including today for another patient that is incarcerated at Washoe County Sheriff's Office. There's certainly times where I look at it and I'm like, this person shouldn't be in jail. This isn't the right place. I think their medical condition is so extreme that they need to concentrate on that. And that's not the sense that I get with the case or care from Mr. Hillygus.
Dr. Wade, thank you for your time. The court will note that Mr. Hillygus had more questions and he would object to the court ending Dr. Wade's testimony, but nevertheless, the court finds that he served the purpose that the court directed a representative to be here today for. Dr. Wade, you can drop off the call. Thank you for your testimony. Wish you a pleasant afternoon.
All right, thank you, sir.
Thank you. I want to remind us all that yesterday I indicated to Mr. Hillygus that if he wanted the court to consider appointing counsel on his behalf to represent his interests with respect to medical issues, the court would consider it. And Mr. Hillygus politely but firmly refused that offer, and it said he's prepared to advance this on his own. So I just want to remind everybody of that. So
I would object.
So hold on.
I would object.
Please don't talk over the court, Mr. Hillygus. I'll give you a chance in a moment to be heard on what we've done here today and what the court just commented about. So, Mr. Stege, what have we learned and what do you ask of the court to do with respect to the oral request to postpone this trial?
It's the defense motion, right?
Well, I want to hear from the state.
Rule 15 requires good cause. It also requires an affidavit. Today what happened is the court ran his motion for a continuance for him. He's made no case for it. Every witness today said there's no impediment to him proceeding forward. The court's not in a position and not called to adjudicate anything about being left outside or about his care and conditions. The question is there a medical impediment to proceeding to trial? A resounding answer is there is none.
Why do you say that?
Oh, there's no evidence for it. He has no chronic conditions that would prevent him from going forward. He has no mental health issues that require even daily care. His daily medical care is rather benign, right? Low level. He is a high maintenance by his own, and I asked the court to reflect on what we learned from the evaluations related to competency. There's no barrier to competency. As a personality feature, he's a hard person to get along with. He's demanding of the medical staff. They have attended to all of his needs. In the entire time he's been in the Washoe County Jail, there's been no medical impediment to proceeding to trial. There's no psychological, sort of the mental health aspect. There's none to be had. So there's no evidence that would lead to good cause, right? Good cause because he's too sick, doesn't feel well. He hasn't even made a case. His own motion was really nothing. And today, everything we learned about Mr. Hillygus was not a concern for being able to participate in this trial. So I can say more about his ability to prepare, etc., but he hasn't made the case. I'm not going to make the motion for him, but I'll say the man has had many years to prepare for this trial date, and it is I think it's obvious as it gets closer, his own anxiety leads him to attempt these delays. The court should also reflect on the GR and PR cases that are the foundation for this case in which the defendant was found to be vexatious because of his repeated delay tactics, repeated and numerous delay tactics. If the court were to summarize in one word, is there anything wrong with the defendant that prevents him from going to trial? The answer is no. Has he made a case for not preparing or the inability to prepare? The answer is no. So 2 no's equals we're going to trial next week.
I understand your position. Mr. Hillygus, I'll hear from you then from Mr. Silverberg.
Once again, I object to this hearing completely as I've not been provided a witness list. There's been no evidence submitted in this case. There's been no emails that have been ordered to be provided for my grievances. There's been no provider present that's personally evaluated me, with the exception of Kendra, who said she took my vitals one time. I have legitimate injuries. This is uncontrolled when I'm being left outside. This happened. The time frames can all be determined by videos that are not being provided, just talked about. I have not seen or been provided those. Like I said, I've not been provided any evidence for today's hearing. And for Mr. Stege to bring up the civil case, I want everything stricken because that's biased, talking about a vexatious litigant in a civil case. This has no bearing on this criminal case. And by doing that, it's a creating a bias against me by this court and by anybody listening to this case. Because if it's all about the civil case, which it is, then it's a civil case. There should have been an order issued in the civil court, and it wasn't, because this was a civil case. This isn't a criminal case. I did not kidnap my mother. She wanted to leave. She requested to leave. She was a resident, not a patient. She had the right to vote.
Mr. Hillygus,
And so if we're
Mr.
talking
Hillygus.
about the civil case, then it
well,
is a civil case,
let's be clear.
not a criminal case.
The reference Mr. Stege made was to the PR case, that's a probate, and to the guardianship case,
It's a civil case.
to two non-criminal justice cases. But this decision on whether this case goes forward will not turn on the court's understanding of what happened in those proceedings are gonna happen. It's gonna turn on what's happened here and your current physical condition or mental health condition. I have no evidence whatsoever of mental health concerns at this point. You're not being treated, you're not being diagnosed, nobody's come forward with that. And we've had a hearing on competency, so that's not an issue. And then the physical. Now, frankly, the court's convinced that you're not a picture of health. You've got things going on. And some of them more serious than others. But that's not the test. The test is whether these are a material impediment to your ability to go to trial. You say it is. The state says it's not. I'm going to hear from Mr. Silverberg in a minute. But what else, other than objecting to this, other than objecting to what Mr. Stege said, what other information do you want me to focus on in making a determination whether this case goes to trial on Monday?
I am being improperly isolated and in solitary confinement in the infirmary. I am qualified by the NAFCARE as receiving ADA accommodations. I have been provided a wheelchair. I do have extensive background with medical injuries and therapies. I have received and fallen in that facility, which is trying to be covered up. I did have a fall there. I was left outside. I was treated. I was prescribed medication. There are side effects for those medications. And I'm not having a table or a chair to sit in a cell where I'm being sleep deprived. And I need a continuance, and I need to be moved to a proper location where I can properly prepare for this case.
Mr. Silverberg.
Thank you. Your Honor, maybe I heard things a little different from testimony, but what I heard was that Mr. Hillygus is placed in the infirmary right now. And our doctor who testified by Zoom as much as admitted that that's not an ideal place. There's a lot of things going on in that infirmary that would, and let's remember, Mr. Hillygus here is representing himself. This is not somebody who's got the lawyers doing all the work for him, so no big deal if he's in the infirmary. But this is somebody who faces the bulk of the allegations in this case that needs the time and the space to represent himself. And if he's in an infirmary where there's all this craziness going on, and he's on medication that's making him sleepy as well, I don't know how the man's supposed to prepare. The doctor immediately said, oh, well, we can move you. So that leads me to question, why is he there in the first place? So there are concerns. I'm not Mr. Hillygus' lawyer, but there's concerns, and I will state again that to the extent Mr. Hillygus is not ready, that has an adverse effect on Mr. Handte. So I'm very concerned about his placement. I was very concerned about how willing the doctor was to, hey, we can move you today. Why is he there then? Everybody knows that the infirmary is a kind of a crazy place to have to be. I can't imagine trying to represent yourself in that sort of situation. And then he's got these medications. So
What do you make, let me interrupt you, I'm sorry, but what do you make of the state's argument that this is the crunch before the trial begins, but what about the last 2, 3, or 4 years? This case, the allegations are that criminal activity occurred in 2019. The case was brought in 2021. What about all the preparation work that ought to have occurred for the 2 years leading up to the last month?
it's a great question, Your Honor. It's a great question, which leads me to ask, why is the state giving us 89 witnesses yesterday? Why is the state giving discovery dumps daily right before trial with things that they've had for a very long time? So what's good for the goose is good for the gander on that, Your Honor. And I'm very concerned about that. looking at NRS 174.234 that says, yeah, 5 days. But it's everyone known to the state that the attorney, the prosecuting attorney intends to call. Does the state intend to call 89 witnesses? If so, we're going to need more time. Otherwise, I would consider it a litigation tactic that is not palatable and should not be accepted by the court. The court should direct the state to give a realistic list of people he intends to call, or we might need to just start looking for a new date now and probably need about a month worth of trial.
Well, if this is an oral motion on behalf of your client to continue, I'm not going to consider that.
I understand that Your Honor should know what's going on here, because if it's affecting me, how's it affecting Mr. Hillygus, who's trying to represent himself? How's he supposed to deal with 89 witnesses dumped on him yesterday?
And I haven't even been provided those. I have not seen that. It's not been provided to me.
It's a problem. And I don't think this case is ready to go forward on that basis. But I also think just standing alone with what Mr. Hillygus has elicited from the witnesses and his argument, where he's been located, the medication that he's on, I don't know how a person who's representing himself is supposed to be ready. And now we also have 89 witnesses. So I understand the court's question that, gee, what's everybody been doing for the last 2 years? Well, I have that same question for the state. I have that same question.
I understand your position. Mr. Stege, would you care to respond?
We're not here for an interrogatory from Mr. Silverberg. It was mentioned yesterday, that rule, which I just pointed out to him, and I complied with. So we're not here for an interrogatory by any means. It's not before. It's not clear he's on that medication. It's not clear he's suffering those side effects. It's his motion. He can testify that he's experiencing those effects. It's not clear why he's in where his housing is. Everyone deferred to the housing situation. The state's belief is that because of his behavior, his housing needs have had to be amped up or ramped up, meaning that sort of misbehavior has caused his housing situation. So the court said yesterday, it's helpful to come back to the law. The law says upon affidavit, the court can continue for good cause. Mr. Hillygus propounds that it's because of medical. Medical, I think he has failed on that charge. As to lack of preparation, I mean, it is rather stark that he now says, right, he was here for the motion to confirm, the case got confirmed, and then only yesterday he brought this issue up. If this case is not going to trial next week, when is it? Because this case, outside of the GR and PR cases where the defendant is a prolific delayer, even within this case, the defendant's own conduct has resulted in very significant delays. The fact of his incarceration is due to him fleeing this jurisdiction. His own actions put him in custody. Now stepping back for a moment, it is very often the case, or I'll say frequently, lawyers ask for continuances at the last moment.
Well, it's not unheard of.
It's not unheard of, right? And so there have been instances where an attorney is ill or for other reasons.
Outside the person's control, usually.
Outside the person's control, a court in its judgment grants a continuance. And of course, there's a whole host of reasons that a court balances or weighs in order to make that decision. But because of the way the motion was made here, the real motion is I have this medical stuff, which is frankly not proven up. The separate issue of whether he is prepared, the court would need to hear more from him, and the court would need to engage in a credibility exercise and believe the defendant when he says he will be ready or that he's not prepared. Because there have been so many delays in this case, and so many instances of the defendant, even today, in the way the defendant would not sort of respect the authority of the court. If the court were to continue this case, he will not prepare. he will delay the matter again. Though the guardianship case took so long because of the delay tactics of the defendant. He was declared singularly, in my knowledge, to be a vexatious litigant. So the court would have to engage in that exercise and believe if he says, I need more time. Now, the state of Nevada would take great offense if this court said, the sheriff's, you're to move this man to another area. This is a game, right? In the way that he's hired, he is so difficult with the medical staff, he would then take that and have the court making orders on his housing conditions. So I think a continuance is not appropriate. Justice delayed truly is justice denied. That delay always is bad for the state. And there's no cause to continue this. Thank you, Judge.
Thank you.
Your Honor, if I may, just briefly, Mr. Hillygus isn't going anywhere. There's there have been delays in this case, but I guess what we really want to look at too is, do we want to do it all again? If there were grounds for a continuance, and or do we want to get it right, do it right the first time and give this man who's representing himself every opportunity? I think he has made the case as to why he has not been able to prepare, and his medical condition is part of it, and it's also his housing. Nobody's asked the court to move his house, to order that he be moved. I was commenting on what the doctor said, that wow, we could have that discussion today. So I think it's a pretty good question that, well, why hasn't it happened before? So for whatever reason this is where we are today. And where we are today is Mr. Hillygus is not in a position to prepare, and that has an adverse effect on Mr. Handte.
Okay, I'm going to let everyone speak twice. I'm going to let Mr. Hillygus be heard one more time if you'd like to address the court based on anything he's just heard, and then I'm going to go to Mr. Stege, and then the court will make a decision. Mr. Hillygus.
I want the court to know that I get along with all the staff. I get along with the medical providers. I get along with everybody, my cellmates. I'm not a problem at this facility. I'm talking out about things that are happening that I don't like, that are affecting me, but I get along with everybody, the medical staff included. I've never been, and there's nobody testified here that that I don't get along with anybody, so I would object to that. I've never asked for a continuance in this case. In fact, I've asked for this case to move forward quickly. The only reason I'm asking for a continuance now is there's legitimate concerns. It's out of my control. When I was left outside, that was legitimate. That happened. I had a fall injury that I'm just now getting the therapy for 5 months ago. It's out of my control. I've been told that the physician that got it approved and scheduled wants me to get in there ASAP. But that's out of his control. So I have an appointment that I'd like to attend to. And I do have legitimate medical concerns. I know they want to downplay that I don't have medical issues, but I absolutely do. I've not been provided a witness list today or yesterday. So I'm this understanding that there's 89 witnesses, I have not seen that. I was just provided yesterday more discovery on a thumb drive, which I haven't been able to access with this laptop because I'm in the infirmary once again. So I agree with Silverberg here that the witness list appearing last minute, the more discovery being dumped, 6,000 pages being dumped on me less than 2 months ago, where it was 300 for like 4 years. Today was ambush evidence once again. I was not provided anything. And saying that I fled and I was not provided what's called due process to file a writ of habeas corpus from Missouri. And I still have not to this day been provided the governor's warrant. And so I do still have a valid writ of habeas corpus, which needs to be filed because I've not seen the governor's warrant. You've ordered the state to provide me everything, and they have not provided me that. That's an important piece of evidence that I need. A lot of this stuff's out of my control, but when this did happen, I'm now asking for the proper time and the due process to be able to effectively do what I need to do to defend myself. And though I wasn't prepared for what was going to happen today, to call the witnesses had I had the grievances which have been denied.
Your Honor, it was Mr. Hillygus' motion. I think you should have the last word, not the state.
I agree. All right, give me just a moment here. The file is quite voluminous, so I apologize. It's just taking me a moment or two to pinpoint a few prior rulings of the court I want to focus on as well. It's not lost on the court that the final decision on Mr. Hillygus' competency to proceed to adjudication was made by the court on June 12th, less than 3 months ago. And Mr. Hillygus has raised concern about his ability to prepare in light of his current status at the jail and also medical health concerns. Counsel for Mr. Handte has indicated that the court's decision on moving this case forward at this time may adversely impact Mr. Hante's ability to defend himself in this case. Excuse me. On the other hand, the state argues, first we've heard of a motion to postpone this trial based on medical issue was yesterday, orally. And then the court made arrangements to take testimony on that today in your argument. Mr. Hillygus observes that he's been approved for possibly special therapy at this time, although it seems to the court that he's been approved to be evaluated for possible needs for physical therapy on behalf of a disc issue. I'm not minimizing that, that's important. I'm also aware that, according to Mr. Hillygus, he's currently being housed in the infirmary, and with the limitations and challenges that go with that. I'm also aware that Mr. Hillygus maintains he had a fairly serious medical episode recently, heat related. On the other hand, hearing from the medical professionals that have been involved, overseeing or directly related to Mr. Hillygus, they don't see those as impediments. State asked the court to consider the delay that's already occurred, some of it brought on by the actions of the accused. State asked the court to take essentially judicial notice of the strategies and approach being used by Mr. Hillygus and other matters. Mr. Hante's counsel observes, these aren't the words that are being used, but the implication being a little bit unfair to adhere to the letter of the rules and then identify more than 80 potential witnesses in this case. The court is aware that potential witnesses are identified all the time that include a long list of potential testimonial persons, and it ends up being considerably less that actually are called. Indeed, I'm trying to remember the last time I saw a list of witnesses and everyone was ultimately called. State is playing by the rules, even if defense doesn't like how the rules are written. Court does not find good cause to continue this trial. Again, Mr. Hillygus might not be the picture of health, but the court finds that what's been presented is not a medical impediment, nor do I find the manner in which the state has conducted itself justifies a postponement of the trial. The court is well aware of the concerns raised by Mr. Hante's counsel, well aware of the concerns raised by Mr. Hillygus. Nevertheless, the court determines that this case will not be postponed. Case goes forward Monday morning at 10 o'clock. That's when the jury will be called down. Now, everyone can catch their breath on that. I've got two more matters I need to discuss with counsel. One, the court had a placeholder, if needed, for 9 o'clock in the morning hearing Monday on the motion to quash subpoena that was served on Debbie Hillygus. The court didn't firm that up because it didn't know what the results of this hearing would be. The court wants to firm that up now. Any reason anyone can think of why that hearing should not proceed at 9 o'clock Monday morning with trial to start immediately thereafter? Mr. Stege?
No.
Mr. Silverberg? Mr. Hillygus? All right. All right. So then let's move over to, there's been a media request from Channel 4 News to have a camera aside and separate from that being used by our Nevada judges for the trial of this matter. Again, it didn't bring it up, it was just communicated to the court yesterday, but now that we're going to go to trial, I want to bring that up. The messaging, and I believe it was forwarded to all of you by email or a letter delivered, but in any event, our Channel 4 says, Judge, we would like permission, consistent with the electronic coverage rules, to video the trial, which, for the same reasons our Nevada judges is being allowed to do so, the court intends to allow Channel 4. The difference being that there would not be a pool camera on the days that they would both be here, because as I understand it, Channel 4 has a deadline that our Nevada judges does not. So they want the flexibility to have a separate camera so they can leave when they need to and do their thing. On the days that they won't be here, they, I understand, would agree to collaborate with our Nevada judges. Does either side have strong feelings they'd like to communicate to the court on that issue? Mr. Stege?
No.
Mr. Silverberg?
No, Your Honor.
Mr. Hillygus?
No.
All right, Channel 4 News then is authorized by the court to proceed. Excuse me, I'll see everybody back here tomorrow morning at 9:30. I will have the redacted jury veneers. We'll also mark exhibits and we'll move forward. All right, thank you everyone. Court's in recess. Oh, one more thing. The court did not review or consider what had been marked as Exhibit 1 to these proceedings. I'm inclined to return them to sender, so to speak, and because I didn't consider it. I skimmed the first page to see what it was, and it appeared to be a communication from the doctor, but I didn't read it substantively whatsoever. All right?
It should probably be in the record just the same, Your Honor, to protect Mr. Hillygus.
Okay, we'll make sure it's Exhibit 1, but again, the court did not rely on it in making this determination.
Understood, thank you.
Thank you. Thank you, everyone. The court will be in recess.
All rise.